evidentiary harpoon. And what that basically is an attempt by a witness, usually like a professional law enforcement officer or other experienced professional witness, who it's a statement or blurting out of evidence that was already deemed inadmissible and that will be objected to, but it's blurted out in the presence of the jury with the idea of the jury's heard it, and once they've heard it, they can't unhear it. And even though the judge will strike it from the record and admonish the jury to disregard, if the evidence is bad enough, it may be impossible. Now, the reason I talk about this is another example of why you want to have a good lawyer on your side when you go to court. Because this is a tactic that gets used from time to time. It's not, it is a violation of a number of laws in terms of procedure and constitutional rights, but it does happen, and it can happen to you unexpectedly. And if you don't understand the law on this, if you don't understand the appropriate way to address a problem like that, it's the kind of thing that can make the difference between having a successful outing in court and not. So I talk about this just as an example of why it's really important, if you are facing a contested matter, particularly in criminal court, but in any court. This kind of thing is one of the many threats out there that you can get tripped up by if you're not aware of it going in the door. And I mean no disrespect to anyone's intelligence when I say this, but going into court is a specialization, just the same as surgery is a specialization, and you can be extremely bright. And I also think you probably wouldn't attempt surgery on yourself. Likewise, you can be extremely bright. If you're not an experienced attorney, an experienced trial attorney who is familiar with these kind of tactics, you can still get hammered pretty hard in court. It's not a reflection on your intelligence, it's just a fact of life. If you're not familiar with that specialization, you can get hammered, and this is one of those ways that's a problem. So the evidentiary harpoon, the response would be obviously do object, and then the attorney on that side would ask for a in-camera hearing as to the particulars of what was said and how bad the damage was, whether it was intentional or not, etc. And then the judge will the relief the judge has available is to either admonish the jury, or if the judge feels it's necessary, and this is what the defense would ask for, is a mistrial. In other words, trial stops, you get a new jury and start all over again. Because the point of the evidentiary harpoon is it's based on this idea that you can't unring the bell. Once the jury's heard something, they've heard it. And even if they're told not to consider that in the evidence, it could still unconsciously impact their opinion on the case. So it is a particularly dirty and underhanded trick, and it does get used.